720 ILCS 530 seconds minus 2 from CH 38 par 32 minus 2 sec 32 minus 2 perjury. A person commits perjury when, under oath or affirmation, in a proceeding or in any other matter whereby law the oath or affirmation is required, he or she makes a false statement, material to the issue or point in question, knowing the statement is false. Emphasis added. The Criminal Code, 720 ILCS 5/16-1, cited in the above criminal charging instrument of the State of Illinois states, 720 ILCS 5/16-1, A1, and A16-1. Theft. A person commits theft when he or she knowingly obtains or exerts unauthorized control over property of the owner. A intends to deprive the owner permanently of the use or benefit of the property. The first element of theft, the charge must allege the knowing exertion of unauthorized control of the property of digital dog, the iPhone 6. The allegation exists but that is fraud on the court, and because the complaint was signed under oath, the allegation is perjury. The common law agreement flies in the faces of the complaint because digital dog knowingly, intentionally and willingly handed the iPhone 6 to defendant according to the signed common law agreement. That defendant was vested with the authorized possession of the iPhone 6 by the signature of the representative of digital dog, as clearly demonstrated and stated in agreement. A copy is attached to the police report but omitted in the complaint, and Hernandez fully knowledgeable of that. Furthermore, the police report also flies in the face of Hernandez because in the police report Hernandez stated that defendant had a loaner phone, which also leads to the authorized possession by agreement. Therefore, Hernandez alleged element of knowingly exerted unauthorized control of iPhone 6 is untrue because it contradicts Hernandez's documented statement in the police report and contradicts the facts of the common law agreement in which defendant exerted the possession of the iPhone 6 by the authority of the signature of digital dog's representative. Furthermore, in the second element of intends to deprive the owner permanently, the police report flies in the faces of the complaint because Hernandez knows the statements quoted above from the police report, which states that defendant was willing to make payments for the price of iPhone 6 but digital dog insisted on a one-time full payment of the retail value of the iPhone 6, which was also stated in the police report to be beyond the financial ability of defendant. Therefore, defendant did not intend to permanently deprive digital dog of the iPhone 6 in any way, shape or form. Accordingly, the elements stated in the complaint against defendant are fraudulent and perjurious, that the charge is void, which also does not vest the court with jurisdiction. 720 ILCS 5/1-5 A1 and C 1-5 State criminal jurisdiction. A person is subject to prosecution in this state for an offense which he commits while either within or outside the state by his own conduct or that of another for which he is legally accountable. If the offense is committed either wholly or partly within the state, or b. an offense which is based on an omission to perform a duty imposed by the law of this state is committed within the state, regardless of the location of the offender at the time of the omission. Emphasis added. In order to protect digital dog, Hernandez voluntarily, intentionally, knowingly and willfully, while under oath omitted the facts of digital dog's consumer fraud and deceptive business practices, b. omitted the facts of digital dog's deceptive advertising in the sale of the defective LG to defendant, c. Omitted the facts of Digital Doc's failure to honor the warranty. D. Omitted the facts of Digital Doc's failure to repair LG. E. Omitted the facts of the existence of the common law agreement. F. Omitted the facts of Digital Doc's recycling defendants LG. And G. Omitted the fact of defendants' willingness to make payments for the loan of phone. The omitted facts are material facts to the issue of the charge against defendant. Therefore, Hernandez has also committed the offense of omission because it was his duty to state all the facts in the charge in order for the court to be fully advised in the premises. 720 ILCS 5 quarters. Sec. 4-1. Voluntary Act. A material element of every offense is a voluntary act which includes an omission to perform a duty which the law imposes on the offender and which he is physically capable of performing. 720 ILCS 5 quarters -4 sec. 4-4. Intent. A person intends or acts intentionally or with intent to accomplish a result or engage in conduct described by the statute defining the offense when his conscious objective or purpose is to accomplish the result or engage in the conduct. 720 ILCS 5 quarters -5 A and B. Sec. 4-5. Knowledge. A person knows or acts knowingly or with knowledge of A. The nature or attendant circumstances of his or her conduct described by the statute defining the offense when he or she is consciously aware that his or her conduct is of the nature that those circumstances exist. Knowledge of a material fact includes awareness of the substantial probability that the fact exists. The result of his or her conduct described by the statute defining the offense when he or she is consciously aware that the result is practically certain to be caused by his conduct. Conduct performed knowingly or with knowledge is performed willfully, within the meaning of a statute using the term willfully, unless the statute clearly requires another meaning, and the law provides that acting knowingly suffices to establish an element of an offense. That element also is established if a person acts intentionally. Whether the charge does not state the nature of the elements of the charge does not particularize the offense, and whether the charge is without a probable cause, insufficient and void. With further examination of the complaint, it is clearly apparent the cited statute of the charge defines the offense only in general terms, and therefore, the May 26, 2016, complaint does not seem related, in any way, shape or form, to the police report, and not connected to the material facts omitted by Hernandez. Furthermore, on October 25, 2016, the court ordered discoveries in the complaint. Against defendant, no discoveries were provided by the state's attorney in compliance with the court's order. The only documents were provided by the state attorney to the defense was the police report where the agreement is attached. Furthermore, the similarity of the words with the added emphasis used in the complaint and in the language of cited statute are identical. Therefore, the complaint should have never been filed for reasons such as but not limited to the followings. The complaint is not allowed by the criminal code because it is punishing for alleged breach of agreement controlled by the common law, civil law as stated above, and defendant reinstate and included here all the above as if it is stated here. The complaint, which is the charging instrument here, is insufficient, for it defines theft only in general term of the cited statute because it merely tracks the language of the statutes. Illinois Supreme Court in People v. Myers, 158 Ill 2D 46 51 states. W. Henna statute only defines a crime in general terms. A charging instrument that merely tracks the language of the statutes is insufficient. People v. Yarborough, 162 Ill. App 3D 748 5th Dist. 1987. Emphasis added. The complaint against defendant fails to specify the particulars of the charge to enable Defendant to prepare his defense. Therefore, a statutory written motion by the defense should be filed to require the state's attorney to furnish defendant with a bill of particulars BP containing such particulars as may be necessary for the preparation of the defense. In this charge, without the particulars of the alleged offense to confine the prosecutor to follow BP and try to prove in the trial, it is not known what the prosecutor shall produce as evidence or what will try to argue or prove during the trial. Article 1 Bill of Rights. Section 8. Rights after indictment. In criminal prosecutions, the accused shall have the right to appear and defend in person and by counsel, to demand the nature and cause of the accusation and have a copy thereof, to be confronted with the witnesses against him or her and to have process to compel the attendance of witnesses in his or her behalf, and to have a speedy public trial by an impartial jury of the county in which the offence is alleged to have been committed. Source: Amendment adopted at General Election November 8, 1994. Defendant's constitutional right to have a bill of particulars to inform him of the nature and the cause of the charge is violated because neither the prosecutor provided discoveries to compliance of the court's order nor provided BP, and the defense did not file for a motion for a bill of particulars. 725 ILCS 5-111-6 from CH 38 par. 111-6. Sec. 111-6. Bill of Particulars. When an indictment, information or complaint charges an offence in accordance with the provisions of Section 111-3 of this Code but fails to specify the particulars of the offence sufficiently to enable the defendant to prepare his defence, the court may, on written motion of the defendant, require the state's attorney to furnish the defendant with a bill of particulars containing such particulars as may be necessary for the preparation of the defense. At the trial of the cause, the state's evidence shall be confined to the particulars of the bill. Emphasis added. Source: Laws 1963, p. 2836. Illinois Supreme Court in McDonald v. The People, 126 Ill. 150, 1888, stated, undoubtedly the people are then confined in a criminal case to proof of the allegations set forth in the Bill of Particulars. Emphasis added. The Bill of Particulars should provide a detailed account of the nature of the conduct alleged to form the basis of the underlying criminal charge against defendant. Illinois Supreme Court in People v. Whistler 108 Ill. 2D 389, 1985, states, if the defendant desires additional specificity, he or she can move for a bill of particulars pursuant to 725 ILCS 5-111-6. Emphasis added. That, the state's bill of particulars, which provides precise conduct the state will seek to prove at trial. Defendant is entitled to have a bill of particulars BP from the state, therefore, the statutory motion for BP should have been filed and granted for defendant to enable him to prepare his defense. However, no motion for BP was filed. 725 ILCS 5-114-2, A from CH 38 par. 114-2. Sec. 114-2. Motion for a bill of particulars. A written motion for a bill of particulars shall be filed before or within a reasonable time after arraignment and shall specify the particulars of the offence necessary to enable the defendant to prepare his defence. Emphasis added. The complaint against defendant is deficient because it is couched in the general language of the statute, because the charge of theft is defined only in general term, and it does not sufficiently set forth the elements of the nature of the charge does not contain sufficient allegations of the offence, the complaint does not particularize the alleged charge, it contains a charge solely in the language of the statute, and the fact of the alleged breach of agreement is omitted, therefore it is not sufficient. The court in People v. Stout, 198 ill. App 3D 124 at 128, 1990, states, the defendants argue that the complaint does not sufficiently set forth the elements of the offense charge. Therefore, the complaint is deficient. We agree with the defendants. We find that neither of the above elements was sufficiently set forth in the complaint. Where, on the other hand, the statute defines the offense only in general terms, a charge couched in the language of the statute is insufficient. Girders, 173 ill. App 3D at 1029. This portion of the charge is alleged in the language of the statute. Since Section 31-1 does not particularize the offense, the complaints which contain a charge solely in the language of the statute are not sufficient. Emphasis added. The